Ladies and gentlemen, fellow Americans, gather round because today we're diving into a scandal that's been festering in our halls of justice for far too long. Have you ever felt like the system is rigged against you? Like the very guardians of our Constitution, the judges sworn to uphold it, are turning a blind eye to laws and rulings that trample on your rights? Well, buckle up, because that's exactly what's happening, and it's time we call it out. Let's start with the elephant in the room, the Chevron deference rule. For 40 long years, from 1984 until it was finally overruled in 2024 by the Supreme Court in Loper Bright Enterprises v. Raimondo, judges handed over their power to unelected bureaucrats in federal agencies. This so-called deference meant that if a law was ambiguous, courts would just shrug and let agencies interpret however they wanted, as long as it seemed reasonable. Reasonable? To who? Not to the everyday people whose lives were upended by overreaching regulations without a shred of clear constitutional backing or congressional approval. Think about it. Agencies like the EPA or the FDA could twist statutes into knots, imposing rules that harm small businesses, farmers, and families, all while judges sat back and said, close enough. This wasn't just lazy, it was a betrayal. The Constitution vests judicial power in the courts to check the executive branch, not to rubber stamp it. Yet, for decades, judges lacked the integrity to stand up and say, no, this violates the separation of powers. They prioritized bureaucratic convenience over the people's rights, allowing unconstitutional overreach to stand and cause real harm, lost jobs, stifled innovation, and eroded freedoms. Why? Because it was easier to defer than to do their damn job. But Chevron isn't an isolated case. Oh no. Our judicial history is littered with rulings where judges allowed unconstitutional garbage to fester, violating the very rights they were meant to protect. Take Plessy v. Ferguson in 1896. The Supreme Court upheld separate but equal segregation, claiming it didn't violate the 14th Amendment's Equal Protection Clause. For nearly 60 years, this abomination stood, enabling Jim Crow laws that dehumanized millions of Black Americans. Judges knew it was wrong. The dissent called it out as a stain on justice. But the majority? They lacked the spine to strike it down, letting racial oppression thrive under the guise of law. Or look at Korematsu v. United States in 1944, where the court greenlit the internment of over 100,000 Japanese Americans during World War II. No due process, no evidence of wrongdoing, just fear-mongering and racism. The judges claimed it was a military necessity, ignoring the Fifth Amendment's protections against deprivation of liberty without due process. This ruling stood for decades, a black mark on our history, harming innocent families and setting a precedent for government overreach in times of crisis. Where was the integrity? The courage to protect the people from tyrannical executive actions? And don't get me started on Bowers v. Hardwick in 1986, where the Supreme Court upheld sodomy laws criminalizing private consensual acts between adults, trampling on privacy rights implied in the Constitution. It took until 2003's Lawrence v. Texas overruled it, but in the meantime, lives were ruined, people arrested, shamed, and marginalized. Judges allowed this violation of fundamental liberties to stand, prioritizing outdated moral judgments over constitutional protections. Now, let's talk about the sneaky part. Case law that's not even a binding decision, but somehow gets treated like gospel. I'm talking about obiter dicta, those offhand remarks and opinions that aren't central to the ruling, but influence lower courts and agencies for years. These non-decisions worm their way into precedents, allowing unconstitutional practices to persist without ever being properly challenged. For instance, in Chevron itself, the court's casual endorsement of agency deference wasn't even necessary to the case, yet it spawned a monster doctrine that harmed the people it was supposed to protect. Judges let this fluff stand, causing ripple effects like unchecked regulations that burden citizens with no recourse. It's judicial cowardice at its finest, hiding behind stare decisis, the principle of following precedent, even when that precedent is rotten to the core and violates our rights. Folks, this isn't just history. It's happening now. Even after Chevron's fall, bad precedents linger, and judges continue to defer in subtle ways, failing to scrutinize laws that chip away at our freedoms. Why do they do it? Power plays, political pressures, or sheer lack of integrity. Whatever the reason, it's we the people who suffer, the very ones the Constitution was written for. Our founders entrusted judges to be the bulwark against tyranny, not enablers of it. So what can we do? Demand accountability. Support reforms that hold judges to higher standards. Vote for leaders who appoint principled jurists. And spread the word. Share this video. Comment below with your stories of how unchecked laws have hurt you. Together, we can reclaim our Constitution from those who betrayed it. Thanks for watching. Hit that like button if you're fired up. Subscribe for more truth bombs. And let's fight for the America we deserve.